Welcome to the Probate Nation. I am Richard Ruddy and I'm the host this evening. We continue tonight with our series on obtaining the legal authority as a guardian and conservator for an adult in Fairfax County. In part one of this program, we learned about the legal process you can initiate to acquire legal authority as a court-appointed guardian and conservator if your parents live in Fairfax County. We learned about the bonding requirements, what needs to go into the pleading to the court, the role of the guardian ad litem, and the court hearing to act on your request. Tonight we will cover your visit to the probate office to get officially appointed and learn about your ongoing reporting obligations. We are fortunate once again to have as our guests local attorneys with experience in these matters. They will serve as our guides in completing the discussion about all that is involved in the living probate train ride you're about to embark on once you're formally appointed by the probate office. Let me introduce our guest. Our first guest is an attorney at the Fairfax and Leesburg law firm of McCandless and Lillard. Her practice focuses on estate planning, estate and trust administration, adult guardianships, and fiduciary litigation. She is a co-chair of the Fairfax Bar Association Wills, Trust, and Estate Section, and chair of the Virginia Bar Association's Young Lawyers Legislative Committee. She's also a member of the Virginia Academy of Elder Law Attorneys. Our second guest is an attorney and one of the founding principals of Ruttenberg Dickerson, a law firm in Tysons Corner, Virginia. She has a diverse litigation practice, which includes probate, trust, and estate matters, guardianship, and fiduciary litigation. She has tried cases throughout Northern Virginia and the District of Columbia, as well as before a number of administrative bodies. She is a fellow for the Virginia Law Foundation and a member of the Virginia State Bar Council, and serves as a commissioner of the Judicial Inquiry and Review Commission. Please welcome attorneys Catherine Swain and Catherine Dickerson. Ladies, thank you very much for coming back to share your experience. And Catherine Dickerson, I'm going to come to you right off the bat and talk a little bit about the fees and costs. There are a lot of fees and costs that can arise or do arise in the course of any sort of pleading for appointment of a guardian or conservator. Can you discuss who pays these fees?
So let's talk about what the fees would be. The fees would include the filing fee for the actual petition. There would be attorney's fees incurred by the petitioner. There are the guardian ad litem fees, as well as their costs. So if guardian ad litem needs an interpreter or somebody along those lines to help speak with the respondent, there would be those fees. Then there are the respondent's attorney's fees and costs if the guardian ad litem believes that an attorney is necessary for the respondent. And there's various medical reports, subpoena fees, those sorts of things. So who pays for those fees? If the respondent's estate is sufficient, then the respondent actually pays for all of those fees.
And that includes the fees for the petitioner's counsel as well?
Absolutely.
Okay. And are these costs automatically accepted by the court, or does this court kind of screen these things and take a hard look and get the red pen out sometimes?
The court is actually required by statute to take a hard look. The statute requires the court to award reasonable attorney's fees. And it's understandable why, because if the respondent's estate is being used to pay for these fees, that's less money available to care for the incapacitated person.
Sure. Now, at the beginning of part one of this particular series of shows, we talked about the key legal documents that folks should be sure to execute. Documents that might eliminate the need to embark on this living probate train ride. Can you mention those documents again?
So when we're talking about money, we are looking for a durable general power of attorney that enables the person who's appointed to act as though they were the person appointing. We're also looking for medical powers of attorney, maybe even a HIPAA waiver or an agreement to share those documents. So if you have at least those, then we have a solid place to start.
Okay. Now, Catherine Swain, I'm going to come to you. Every day, and everyone these days is especially conscious about costs and trying to be thrifty. In your experience, would you estimate the cost of preparing those very basic estate documents that Catherine Dickerson just mentioned would be less than the cost and fees to get someone appointed guardian or conservator, and plus the ongoing costs thereafter?
The cost for preparing general powers of attorney and advanced medical directive would be much lower than the costs of going to court and getting a guardianship or a conservatorship. Even if the guardianship or conservatorship is uncontested, the cost of preparing those documents would be fractional in comparison. And if the proceeding becomes contested, the cost can go up astronomically.
And I think that's important for people to understand. So we want to be cost conscious and cost savvy. But let's continue on we're now walking down the hallway. We've got our court order. We're heading off to the probate office in Fairfax, which is on the 4th floor. And we go in the front door there and get ourselves signed up. What are the common problems that occur after the court order is entered and you head to the probate office with the order to get qualified? What are some of the common problems that are encountered?
One of the common problems is that something might be missing or incorrect in the order, and the probate clerk may catch this even though the judge has already reviewed and signed the order. If that happens, then we can generally go back to the judge and ask for a correction, but it does depend whether the judge is still on the bench and whether we have done this qualification appointment directly after the hearing where he might still be available. Another major pitfall that could happen at that appointment is that the conservator or the proposed conservator cannot be bonded. And this could happen if, for whatever reason, they don't have a high enough credit score to qualify, or perhaps they are not employed, or they've previously declared bankruptcy. And if we get all the way to that point where the court order has already been entered, then we have a major problem because the conservator cannot be bonded to actually handle the estate.
So I think it's important to kind of pause here for a second. I think if their conservatorship is being sought, one of the very first things out of the gate before you even prepare the petition, probably I know that you and Catherine Dickerson do this, is you'll have them make an application to the bonding company to make sure that we're going to be good to get a bond with surety once the judge enters that order. I think that's very important. I know that you guys do that. Yeah, that's a really good idea. Tell me, what is the amount of the bond that is required for a guardian?
We generally calculate the bond by adding up all of the respondents' assets as well as their annual income, and then multiplying that amount by 1.33. So the conservator's bond is slightly more than the amount of the assets to ensure that they have control over the maximum amount.
So that's the conservator bond. So for the guardian bond, though, I think as we've talked about, that's really just a $1,000 basically personal bond with no surety involved. Is that true?
That's true. There's no surety on the guardianship bond, so it's a personal promise or a paper promise to faithfully perform the duties.
Now, I'm in the probate office. I've got someone sitting next to me. They're getting all their stuff sworn in. Everything looks good. The bond's good. They raise their hand and they get sworn in by the probate clerk, and it's just a delightful time. What do I have to show that I'm in charge now? What do I get?
Ultimately, the probate clerk will give certificates of qualification, and those are the papers that the conservator and the guardian will use on file wherever they need to act for the respondent. So these can be kept on file with the regular medical providers. If the individual is in some sort of day program or schooling, they can be kept there. And then the conservatorship qualification certificates can be kept on record with the bank that the person generally uses or other financial institutions that would need to see them.
Okay, so Catherine Dickerson, I'm going to come back to you now. We've finished our swearing in, we've gotten our certificate, everybody's happy, we're shaking hands. Before we walk out the door, Catherine Dickerson, does the probate office give me any sort of explanation about my responsibilities as a guardian or conservator?
They do. We're actually very fortunate in Fairfax because we have a fabulous probate office and they are very responsive. But what they can't do is give you legal advice. So they have general forms, they have an excellent website, they answer their phones, but there might be situations where an attorney or legal representation is necessary.
Okay, but when you walk out the door, they not they give you a little packet of some kind explaining your obligations as a guardian, and we'll come back to that. I think they also give some documentation that the Fairfax Commissioner of Accounts has put together, and they update that regularly, that kind of walks you through all of the obligations you have and things you need to file. Has that been your experience?
Yes, absolutely. And we're also very fortunate in that our Commissioner of Accounts office in Fairfax is also fabulous. And they are also very responsive. And they have both the probate office and the Commissioner of Accounts office have great websites where you can go and look for additional information that is sort of outside and beyond the packet that they give you.
And no question about that. I mean, it's really fantastic, the websites that both of them have. Catherine Swain, I'm going to come back with you now. What are some of the common reasons why qualification cannot proceed? I mean, we kind of touched on those during the course of our conversation so far, but just to kind of pull it together, what are some of the common reasons we can't get qualified?
Sometimes there may be something important missing or incorrect in the order that the probate clerk catches. So there's certain areas of the order that need to be in a specific font, they need to be bolded, and they need to be in larger print. Those things can completely throw off the order if something has been missed, if a detail hasn't been added. There's also certain statutory requirements that need to be included in the order. And if one of those is missing, the probate clerk will say that qualification cannot proceed. The other item that we just touched on is that the individual, if there's a conservatorship, needs to be able to be bonded for the specific amount of the bond. And this could be an issue because maybe they have pre-qualified with the insurance company, but then the judge changes the bond during the hearing or asks for a higher bond than what was anticipated. And maybe at that point, the conservatorship cannot be bonded or the conservator cannot be bonded to cover that larger amount. So that's another issue where the probate clerk will say qualification cannot proceed. And the last thing is that if an individual is out of state and doesn't reside in the Commonwealth of Virginia and they're attempting to qualify as guardian or conservator, there will be a slight pause, not necessarily that they can't be guardian or conservator or that qualification can't continue, but they'll need to appoint somebody who's a resident agent in the Commonwealth of Virginia to receive notices for them. So if that individual is working with a law firm for the petition, then they can generally appoint the law firm or a lawyer there to serve as the resident agent and handle that step for them.
All good points, all good points. Let's talk about, we've now been qualified. We're good to go. We got our certificate of qualification and we're walking on air as we head out the probate office door. Our lawyer's done a good job. And now all of a sudden, they open the front door and the cold air hits and we realize we have a lot of things we have to do. And so, Catherine Dickinson, let's talk about that. So there's a lot of ongoing reporting requirements after appointment. So talk about what are those reporting requirements to the Department of Social Services?
This is where you grab your attorney and say, don't leave yet. It's a highly detailed report. I don't think anyone who hasn't looked at the statute doesn't appreciate that 6 months after your qualification, you need to let the department know the names of all the medical caregivers. You need to give them the dates, locations, and reasons for every hospitalization. If you've decided that someone should not have access to the respondent, you have to give the reasons why that access has been restricted. It's a very, very detailed report. And if you don't do it timely, there is a fine that's levied against you, the guardian, for failing to file that report.
Yes, and those fines are not things that you can take out of the conservatorship pot. You have to pay that out of your own pocket.
Absolutely.
So the other thing that I think comes up, then of course, once you do that 6-month qualification report, do you have to do that every year?
Every single year, yes.
Well, it sounds like it's an attorney self-employment act to me. Well, let's talk about the Commissioner of Accounts. That's the next group I think people have to do reporting to. Talk a little bit about the reporting obligations that a conservator has to the Commissioner of Accounts of Fairfax.
So the conservator, 6 months after qualification, must do their first accounting, which covers everything that they've done in the first 4 months. Mm-hmm. And then they have annual accountings after that. But please appreciate that this is down to the penny. There is no rounding error. There is no, it's close enough. It's someone else's money. And this is where a lot of people get into trouble because they don't track the receipts. They don't keep copies of them. They don't do the accounting with the necessary formality that the commissioner requires.
Well, and I think that sort of segues into Catherine Swain. I want to ask you, the reporting obligation to the Commissioner of Accounts is often what really does get people in trouble and leads to the removal or lawsuits against them. So can you review some of the key do's and don'ts that every conservator should follow?
Yes, unfortunately, this does get people into trouble. And a lot of times it's not that they were ill meaning or that they meant to do anything improper, but it's just that there are a lot of guidelines and requirements in place that people are not familiar with. So, first, I would advise that they note all of the relevant deadlines. These are not going to be reminded for them. They need to note them in their calendar and ensure that they're meeting those deadlines and that submissions are not tardy, whether it's to the Commissioner of Accounts or the Department of Social Services for the guardianship report. They also need to keep extreme records with all of the dollars and cents. Every penny in and every penny out needs to be recorded and needs to be kept separate in a conservatorship account. These should not be intermingled with the individual's own assets at all. I would also suggest working with a professional, whether it's a law firm that will continue to represent the individual throughout the accountings and the inventories, or a financial professional that can help. But a lot of people try to take on these tasks by themselves in order to save money, but they end up incurring a lot more in fees when things go wrong.
Very true, very true. And I would add that we've had a couple of shows put on by former auditors of the Fairfax Commissioner of Accounts, and they've talked about in detail how to prepare the conservatorship inventory and how to prepare the conservatorship accounting. So these are very, very good shows, very detailed, and will go a long way to making sure you don't misstep. I would add that I think that we're finding that the auditors all want receipts for every dollar you spend. So just having a check and saying it went to so-and-so to cut the grass probably doesn't cut it. You need some receipt from that person saying I cut the lawn 3 times. You won't need a receipt for payments you make to the commissioner. They'll accept that, but otherwise you've got to be careful about that. All right, common problems and pitfalls. I'm going to stay with you, Catherine Swain. So we've covered a lot of ground. We've been into the second stage of this particular play here and trying to get somebody appointed. Now they're appointed. What are some of the common problems and pitfalls that people run into in the process of getting themselves appointed guardian and conservator?
I would say not understanding properly the powers and authorities that will be conferred upon them, making sure that they're able to handle the duties of the Office of Guardian and the Office of Conservator, including those reporting requirements that we just went over. This is not something where as soon as the final order is entered, the task is done, but really where the road begins. So they need to know exactly what they can do and cannot do and make sure that they have the appropriate powers written into that order before it's actually signed and entered by the judge.
Catherine Dickerson, how about yourself? Can you add some other thoughts about the common problems and pitfalls that people should be prepared for?
Appreciate that this is not a dictatorship. This is decision-making authority, which means that to the extent that they can speak with the respondent and get the respondent's input on this, they need to do so. To the extent that they have to, there are spouses, other children, they have to get everyone's input, especially if they make decisions, for example, to relocate the respondent or to move the respondent into a different facility or a different home or to get assisted care for the respondent. They need to get the input from other family members because a guardian or conservator can be replaced.
Well, that's very good advice. Now, we're at that point now where I'm going to ask you, we've covered a lot of territory, get some final thoughts, practical advice, suggestions beyond the things we've talked about so far, that people should consider and keep in mind as they seek to get appointed guardian and conservator of an adult in Fairfax. So Catherine Dickerson, can you share your thoughts first?
Appreciate that the family dynamics don't go away. So in this day and age where we have second, third, fourth marriages, where we have blended families, those dynamics don't go away. And depending upon what the relationship is, everyone gets a say. Also, appreciate that someone can be guardian and someone else can be conservator. These are very time-consuming positions. You don't need one person to serve as both.
How about you, Catherine Swain? Can you share some final thoughts, advice, suggestions for our audience?
I would suggest meeting with a professional before embarking on this to determine if it's even necessary to go the guardianship and conservatorship route, or whether the individual either has powers of attorney that will work or that they have the capacity still to sign those documents. we want to proceed with the least restrictive means, and these are very restrictive means to go all the way to guardianship and conservatorship. If they do have to be appointed, I would suggest staying as organized as possible. Certainly on the conservatorship side, we want to keep full accountings of every asset that has been touched as conservator. But even on the guardianship side, to stay organized with medical providers and with all the actions that the guardian has taken under that role.
Excellent advice, and thank you guys. I want to thank you both for taking the time for this great public service. I mean, I think that if people who are going to embark on this particular journey to become a guardian and conservator in Fairfax would benefit greatly by watching both of these shows before they go down that path. They will certainly have them in a better position to have good conversations with counsel, which I think everybody would agree is going to be in their best interest. So I want to thank you guys for this public service and hope we can see you again sometime in the future for one of our future shows.
Thank you.
You know, if you need to petition a Fairfax County Circuit Court for the legal authority as a guardian and conservator, what our guests shared over the course of 2 shows should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule, and many of those steps deal with those legal requirements both in the documents filed and in decisions to be made, many of which involve seeking help and guidance from other professionals. My guiding concern as we wrap up these shows is the following. Seeking this authority is not an undertaking you should handle as a pro se petitioner. There are simply too many decisions to be made, too many legal steps that require legal knowledge, and often this is an emotional time for you, the family, and the person you are seeking legal authority to care and act for. I urge you to seek out the assistance of an attorney with experience in these matters before you get in line to purchase a ticket to board the living probate train. You'll be glad you did so. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly guardianship, conservatorship, estate administration, and probate tips, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.